Yes.
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 Thank you.
Yes.
Welcome to the presentation. So today's presentation is titled Estate Planning Essentials, Last Wills, Trusts, and More. So I am Evelyn Sylvester and I'm an attorney in New York City. I do have a solo practice in Manhattan. Just a brief introduction about me. So let's get started. I just want, before I get going, so let me see if I can do that.
Let me see. I got you. Something. Oh,
Yes.
what's the little arrows right here? Yes. Oh, it doesn't. Okay. You would think it would work. Huh. Sorry, folks. There's always some technical difficulties going on here.
So maybe can I do here?
Yeah, you could also do that now. It should be
Okay, sure. All right, so just a brief disclaimer before I get going. This presentation and any accompanying materials are for informational purposes only and cannot be relied upon as legal advice. In addition, note that rules and laws can change often, so the information contained herein is accurate to the best of my knowledge as of the date of this presentation. Little bit disclaimer, and that's out of the way. Let's get started. So today's agenda, I'm going to cover 6 topics. One is House of Attorney. Second is healthcare proxy. Third is guardianship. Fourth, last wills and testament. The fifth one is revocable living trust. And last but not least, a little bit about Medicaid plan. So I just want to start off with a myth about estate planning. Many of you might think estate planning is for wealthy individuals and you don't need to plan anything, estate plan. That's not true. So what will happen if you pass away? So if you don't plan your estate, then the government will decide who gets what. And if you have, considerable assets, then if you don't plan estate, do the estate planning techniques, then it's, you have to pay hefty chunk of tax. Is that what you want? So it could be just a simple will or a complex system of trust that you need. So what is estate planning? Estate planning is a proactive process of planning for the expected and unexpected events. Like expected events, like if you want to go overseas and you want someone to take care of your affairs in New York. So you assign an agent here, to take care of your financial affairs. It will be the powers of attorney agent under the powers of attorney. So it might be unexpected. You go out and then hit by a bus and be in a comatose state. And also it covers the death, everybody in this world at one point has to face the death. So those are the kind of scenarios you expect. So it's when you are alive as well as when you are deceased. So you need to cover all these scenarios and factor into and have all the papers in order. So that's like a proactive. You have to factor all these issues and proactively plan. So that's what estate planning. So it will include wills. People think of estate planning, then everyone should have a will. Absolutely, will or a trust, depending on the circumstances. And also, when you're alive, it's going to be powers of attorney for financial decisions and healthcare proxy for medical decisions. All right, so the comprehensive estate plan. Right, so let's get into, so it should be a like foundation is going to be below trust, comprehensive, yeah. All right, so that I covered. So timing of the tools. So now I've spoken about powers of attorney for health, medical, financial affairs, healthcare proxy for medical, guardianship, then the wills when you pass away, trust, both. So timing of the tools. The powers of attorney or is only effective during life. It ceases when you pass away. It will take, it's effective when you are in a comatose state, lying in a bed in case, But when you pass away, it ceases, it stops to exist. Healthcare proxy also mostly during life, but it might in certain circumstances after death, like when you have authorized someone about autopsy, or when you have mentioned anything about cremation, or or your disposition of remains, what about your funeral? This. So that's healthcare proxy. So it might cover life as well as death. Guardianship is only during life. Wills definitely, only takes effect only after you pass away. Trust, on the other hand, is during life and death. You would have heard about revocable living trust. That's especially revocable living trust. There are zillions of different kinds of trust, but RLT, which is popularly known as RLT, people do that to avoid probate. So that's during life and after death. So that's a little bit about the timing of the tools. Now let's go to. So I'm going to start off with all the documents. So the powers of attorney, it's financial powers of attorney. What does it do? It's a legal document where you authorize an agent to handle your financial affairs and asset management. It gives a trusted person the authority to make financial decisions on your behalf while you are alive. So you are alive and well, and then the powers of attorney agent. You are the principal and you authorize the agent. So both of you can act simultaneously. You can go to the bank and withdraw the money. And your agent also can go to the bank and withdraw the money. So it should be a trusted person. You can go to the bank and swindle all your money and go on. So, if you don't trust the person, so you need to be very cautious so you don't give the authority to him. Things of that nature. All right, so that's asset management. It not only covers going to the bank, it covers a whole host of things like handling real estate, any tax matters, and so many powers, it's granted so many powers. All right, so now we are going to talk about types of powers of attorney. Powers of attorney can be differentiated between timing and scope. So when it comes to timing, there are two types. One is springing. It springs upon an event. Supposing you don't kind of trust, if you don't have anyone, regardless, you want to appoint someone as the agent for the powers of attorney. What you need to do is you can sign a powers of attorney authorizing an agent. But then you say that I was talking to a lady a couple of days ago. She said, I kind of don't have anyone. So what he can do is he can go to the bank once I am incapacitated. So you mentioned that in the section called modification section. It springs upon a certain event when you are incapacitated. Right? So that's called the springing powers of attorney. Then, as opposed to the springing, it's durable. So what is the meaning? If it's durable, it takes effect immediately. And it goes beyond your incapacity until you pass. So that's the difference between springing and durable. So scope is general powers of attorney. But general powers of attorney and then limited powers of attorney. What is general, you give broad authority. All the powers in listed there. I'll come to that in a few. Then limited, you just say, okay, I want this agent to sell only this particular property. And then you mention that in the powers of attorney, your address only to handle the disposal of this particular property. So that's going to be limited only to that specific, real estate sale. So that's the difference between general and limited. All right. So in New York, usually what's the form that is being used is called the New York statutory short form, right? So the execution requirements, how you have to sign it is you need two witnesses. You need to sign in front of two witnesses, should be dated, signed by the principal, and acknowledged, meaning, and also signed in front of a notary. Note there has to be a notary public. So you need two witnesses and a notary. That's you sign, the principal signs. You are giving the authority to the agent. An agent also has to sign. So the power of attorney becomes effective only when the agent accepts, meaning signs, meaning she or he should also sign in front of a notary. There is no need for witnesses, two witnesses when the agent signs. It can be different date and it can even be different state. If your daughter's son is in California, they can do that, but they have to go in front of a notary. So the powers of attorney becomes effective only when the agent signs. One of the things I do at work was, I was working for Medicaid and last week I retired. So one of the things I do is I reviewed powers of attorney. So they comes and there have been, as I told you, the laws change, right? Currently, the current law is effective, became effective June 13th of 2021. So I was reviewing a powers of attorney. It was signed in April of 2026. But so the law, based on the law, after June 13th of 2021, you need two witnesses, dated and signed by the notary. It was signed by the notary, the principal has signed and the agent has signed, but there was no two witnesses. I see on the top, and it says, it's a 2010 older version. So if you are going to do a powers of attorney, please make sure that you don't do the older version. When you go to the computer, and just Google it, you find several versions. So make sure that you are doing the current version, which says on top most of the time, 6/13/2021. That is the current version with two witnesses and the notary. And also, sometimes the agent do not sign. The children, they don't sign. So there is no signature of the agent or the children or whoever who is being the agent, then it's not duly executed because they have not signed. They have to sign in front of the notary. So that's a little bit of, just to give you how execution, signing of the powers of attorney. Okay. So now we are going to come to the powers. I told you can be general powers and limited powers. On page 2, you will see here, if you see this, it's a whole host of powers. A is a real estate transaction, chattel, banking, business, and so forth, tax matters, and all other matters, and fully qualified. So P, so on P, you will see each of the matters identified by the following letters. So instead of initial, you have the initial. You please do not put X. We, in Medicaid, sometimes we don't look into it. We accept X also. There are some people do XX, no X. It has to be initial, your initial. Each and everything has to be initial. Instead, you can also initial the last P. So instead of doing one after the other, you can do A to O, meaning all the powers you have granted the agent all the powers. And also, you might think that, okay, so these cover, all the powers. That's not true. You have still more powers like digital, handling digital affairs, like, digital assets like email. So there is a section called modification section. In the modification section, you can, put all the powers what you want your agent to handle in the digital affair. I want this, my daughter to be my guardian. So that's not here. So whatever you want your agent to handle, you can insert in the section called modification section. So that's a little bit about powers of attorney and a little bit caution about banks' powers of attorney. When you go to the bank and say, okay, I have a powers of attorney, my daughter is the agent, then she says, no, we don't accept this. We have our own forms. And so then you have to sign their own forms and, it's a different, their procedures. That's okay, so long as that powers of attorney does not revoke the powers of attorney you have. Make sure that it doesn't revoke. So supposing you sign that powers of attorney when bank, and then you have this one, it's if it revokes, then you cannot use the one you have. So make sure about that. Okay, all right. So then you might think, okay, what happens if I do not have a powers of attorney? Right? If you do not have your daughter, you're sick, you cannot go to the bank, and you don't have a power of attorney. So what's going to happen? You need to file for a guardian. You need to go to court. If you do not have a power of attorney, your children or anyone cannot go to the bank or, for that matter, anything. They cannot handle any of their financial affairs. So they had to go to courts and file a petition for guardianship. So first they give you temporary guardianship, and then it becomes permanent. So it's a time consuming. You have to go to courts, file papers, wait for the judge to sign. So please, in order to avoid that, you need to have a powers of attorney so that your agent can handle it. It's young or old, a person can meet with an accident. It doesn't have to be old. Any person has to have a powers of attorney. If you're young, and your parents can be the agent. If you're old, your children can be the agent. So that's the bottom line of significance of the powers of attorney. All right, that's basically about powers of attorney. Now we are going to talk about healthcare planning documents. Today, I'm going to cover 4 documents. One is healthcare proxy. Second one is living will. HIPAA authorization. Third, the last one is MOST. Okay. So what is a healthcare proxy? By healthcare proxy, you have paper. So you appoint an agent to make healthcare decisions. In New York, you need to have a separate document called healthcare proxy, so that someone can take your affairs, make medical decisions on behalf of you when you are unable to do so. So there is a difference between healthcare proxy and the powers of attorney. I told you, in the powers of attorney, the agent and you, both of you can act simultaneously. You can go to the bank and withdraw money, although you have powers of attorney, and the agent can go to the bank and withdraw. So both of you can act simultaneously. On the contrary, in the healthcare proxy, the agent steps in only when you are unable to decide for yourself, make decisions for yourself. So think of this as who decides when I am unable to do, when your mental faculties are not working. All right, so that's the gist of the healthcare proxy. What is living will? What does it do? It establishes your wishes. Living will, about life-sustaining treatment, meaning end of life. Do you need ventilators or feeding tubes, resuscitation? When it's used, when you are incapacitated and seriously terminal condition, in a comatose state of affairs. Think of this as what you want. This is a paper with the healthcare proxy. It's also adjacent to the healthcare proxy. It's signed, it's a paper, you sign it. All right, I'm going to come to, so now I'm going to talk to you about MOLST before I talk about HIPAA. So now MOLST, okay, so MOLST, MOLST form, it stands for Medical Orders for Life-Sustaining Treatment. What it does is, it's physician-signed medical order for the end-of-life preference, similar to living. So here, if there is a DNR, do not resuscitate order, and you have it in your wallet, or put it on a refrigerator, and EMS comes when you are in a comatose state. They just break in the door, or they open the door and come, and you have it here, or you have it in the wallet, on your way. So they will not resuscitate you if you have the MOLST order. So the difference between MOLST and the living will, it's the same, it covers the same thing, end of life. But if you have a MOLST, if you discuss it with the doctor and you sign the MOLST order, then they are mandated that they do not resuscitate. But when it comes to living will, that also says the same thing. That's just a paper, that's your wish, you sign it. So it depends, they will discuss it with your family members, and then they decide the pros and cons, and they may resuscitate depending on the circumstances. So that is the difference between MOLST and living wills. Covers the same thing, end of life. One more thing think of this as doctor's orders for end of life care. That's MOLST. Okay, so this is your wish for end of life care, living. All right, so that's a difference. So I'm going to talk about HIPAA authorization. So according to the federal privacy laws, in order to get information about one's healthcare, you need to have this HIPAA authorization. So your family members, spouses and children, they want to call the doctor and speak about their healthcare, lab results, they need to have this HIPAA authorization. So otherwise, family cannot speak to the medical providers. So think of this as you can get information. So that's the HIPAA authorization. So you need all 4 documents to cover you. You are all in good standing when it comes to medical affairs. Works together, healthcare proxy and living will about the end of life, and then HIPAA authorization ensures access to information, MOLST for patients with serious health conditions, and they have very strong will that I do not want to be resuscitated. Then you need to talk to your doctor and get this filled out and sign it and have it in your refrigerator or on your wallet. So that's the summary of the 4 documents about medical discipline. All right, so now a little bit about guardianship. I'm not going to get into it too much. So when does guardianship comes in? When you do not have a powers of attorney, and when you do not have a healthcare proxy. So your children or your family members cannot step into your shoes because there is no papers authorizing them to step into your shoes. That's when the guardianship kicks in. They need to go to the courts, file papers, with the help of an attorney, and then it takes a while, the court process. It takes a while, and it goes in front of the judge, and then judge signs an order for a guardian. So first, he will appoint a temporary guardian, then it becomes a permanent guardian and a commission, so that the permanent guardian can act on your behalf. Once the temporary guardian order signed by the judge, then the temporary guardian can act. So what is a guardianship? It's a court-appointed authority over personal and or financial decision for an incapacitated adult. So court will assess the adult's capability and whether they are at risk of harm if no one steps in. So, and guardianship is the last resort. There is no POA, if there is no healthcare proxy, then you need to go to the courts. Okay, so we have two types of guardianships. It's personal needs and property management guardian. Personal needs takes care of healthcare decisions, living arrangements, and property management guardian pays the bill, manages assets, prevent financial exploitation. So the summary is guardianship can be costly, time-consuming, and strip off your independence. So proactively planning, having power of attorney and healthcare proxy help avoid guardianship altogether. This is a last resort. It's a necessary safety net. All right, so that's a little bit about guardianship. So now I'm going to talk to you about last will and testament. Everybody thinks about last will when they think about estate plan, right? You know that. So what does a will do? It is a legal expression of your desires, of your wishes to dispose of your assets after you pass away. It's necessary to dispose to anyone out of the family. So there is some of the technical words, vocabulary. We come to testator and testatrix. So the will maker, the person who writes a will, is called the testator if he's a male, or testatrix if he's female, if she's female. However, testator is used whether a male or a female, because it's a gender neutral term. So the executor is the one who oversees the carrying out of the directions in the will. It has to be submitted to the courts. The original will has to be submitted to the courts when someone passes away, and it has to be just go through a process called the probate process. It has to be submitted, go in front of the judge. They're going to send all letters to whoever who is the beneficiaries, and the beneficiaries can contest the will. They said they don't get the right amount. Because in case, supposing you say you have 5 children and one child you don't give equal, if all 5 children are given equal amount of your property, then there is no dispute. But in some cases, in one case which I did, there were 3 girls, and one of the girls was disinherited. Because when I met her, the mother, she says, I don't want to give anything to my daughter, second daughter. I said, okay, if that's the case, now she will contest. What happens is it's a will. Once you pass away, it's submitted to the court, and it's public. So if it's public, everybody can look at the will. It's online nowadays. It's online, they can look at the will. And then also what happens is courts will send letters to all of your beneficiaries. There's about 6 months period of time where you can contest. So I told the mother, this is exactly what's going to happen. So we had to put a clause saying that I'm intentionally disinheriting. So I said, you need to put a clause saying I intentionally disinherit my daughter, second daughter, Betty, so that she doesn't get anything. In addition, what I did was, apart from the will, I also wrote my notes saying that I've explained to her thoroughly about the fact that she may contest. Regardless, she was very adamant that she doesn't want to give anything, and she's being disinherited, nothing to her. And I wrote a letter, everything. Okay. Lo and behold, after the mother passed away and is being submitted to the courts, second daughter is disputing the will, saying that she didn't have the mental capacity at the time of the will, and it took 5 years to get the probate certificate. Right. So the bequests are the distributions from your will. They are called bequests, and the beneficiaries are the one who receives those bequests. So those are some of the vocabulary. So what the executor does is, as soon as the person receives, so he has to marshal all the assets and go to the courts, file papers, then the judge issues latest testamentary, and then the executor then distributes the money. He has to also do the debtors, because I've been working with Medicaid, so he has to get in touch. All the attorneys who handle these probate matters, they get in touch with us. And then if someone is on Medicaid, then we give them a claim, and then we negotiate and settle it. So he has to get in touch with the debtors. Medicare, sometimes, when it comes to Medicare, if you're met with an accident and if you're over 65, you are on Medicare. And if you meet with an accident, Medicare kicks in. So they have to get in touch with the Medicare as well as Medicaid for when you meet with an accident. Right? So that's a little bit of Medicare and Medicaid. So that's a vocabulary for the will. And then when it comes to intestacy, hold on 1 second. Okay, how do the will is executed? So testamentary intent. What is the testamentary intent? If you're planning to write a will, you should have the intent that by this will, all my properties will be distributed after my death. You should have a clear intent. That's called the testamentary intent. There are 5 requirements. So testamentary capacity, you need to have the capacity. You should know what you own, what are your assets, and you should know your family members. Who are your family members? It's called the bounty. So you should know this will is going to dispose all of my assets after I pass. So you should have a mental capacity. All right. And the third one is will should be executed freely. Freely in the sense that there should not be any undue influence. So in that case, I was referring to a court case I was talking to you about. What the second daughter said was, the eldest daughter, the only bigger assets was the apartment. She had an apartment, and that apartment was given to the eldest daughter. So the second daughter said that she was unduly influenced by the second daughter to write, so that she has given without her mental capacity. And she was unduly influenced. There should not be any undue influence. Supposing you have 2 children and you live with one of the child, and you have written almost all your assets, giving all your assets through the will to the child. The second child can say that she was unduly influenced, and this is not her will, this is not intent. She was unduly influenced by my older sister, who has gotten all the money. So there should not be any undue influence or duress. The will has to be executed free. And the requirements, it has to be signed by 2 disinterested witnesses. As I told you, the power of attorney needs 2 witnesses. Similar to this is a legal document. It has to go to the courts. So you need 2 disinterested witnesses. Last but not least, there needs to be a self-proving affidavit. What does that mean is, in order for a will to be signed, you strictly need only 3 people, meaning the person who signs the will is the testator and the 2 witnesses. 3 people. However, there has to be an attorney, attorney or notary public who signs the affidavit. It's called the self-proving affidavit. Once you have the will, the testator signs, then the witnesses sign. That's the will. And then you have this affidavit, which says that it's only signed by the two witnesses. It's not signed by the testator. They say that this will was signed today or this day, and we saw her signing it. She had no defects of mental capacity was great, and she had no, her eyes and vision and everything, hearing, no defects, and she knows what she was doing, and then they signed it. Those two signed, and then the affidavit, notary signs. The notary public, it's an affidavit. That affidavit has to be attached to the will. So when you go to the surrogate court and you submit the original will to the surrogate court, when someone passes, the first thing they do is they turn off and they think, okay, they are a self-proving affidavit. There is an affidavit. Okay, signed, all right, great. Then they have. What happens if there is no self-proving, affidavit is not attached to the will, then the witnesses who signed the will has to come in front of the courts when there is a probate process, in front of the judge, and say that how they signed and explain everything. They have to testify as to how this will was signed. Instead, to avoid those witnesses coming in and just taking time, you have to have a self-proving evidence. I will never do a will without a self-proving evidence. So these are the requirements to execute a valid will. So now let's talk about intestacy. What is an intestacy? Intestacy is when someone dies without a will. So I told you, instead of an executor, here is the administrator. Instead of you name the executor, and here the person is an administrator. How does the administrator comes? In the will, you name the executor. So this is the one who will be the executor. You name it. So and so will be my executor, and if he is unable to act or cease to or fails to act, then this one. So you need to have two alternate executors. One is the primary, and then the alternate. So that's the executor who is appointed in the will. Administrator takes over when someone passes without a will, and they sit down after the funeral and they say, okay, now we need to take care of the affairs and who is going to be. So the family decides and administrator. It's not in the will, you don't have a will. So family decides who will take care of the affair, and then he files this almost similar paper. This is called the probate forms, probate petition, and that's the administrative petition. The difference between the two. Okay, so but it's more or less the same papers. It's only on top it says probate for wills. No will is the administrative petition, but it's almost the same information you have to fill out. Only thing is that the executor is appointed in the will. That is the testator who signs the will. He says, "Oh, I want this person to be my executor." So that's the difference between executor and the administrator. So when you die without a will, what will happen is, if you have children and spouse, it goes to your children and spouse only. If you do not have children and spouse, then it goes upwards to your parents in equal share. Both parents are there, then 50-50. If one parent, all 100% to your parents, if your parents are. If you do not have children or spouse, and if you do not have parents, then it goes sideways, all in equal shares. If you think that you want to give some more money or more assets because you are living in the house and you want to do it, and then you need to have a will. So that's the difference between a will, and if you do not have a will, you cannot give it to charity, even if you wish to do so. You cannot give it to your friends, and you cannot give it to your siblings in unequal shares, so long as they do not contest the will. So that's the crux of intestacy. And when you have a will, you can give it to the charity, friends, and unequal shares to the children. So that's the crux of having a will and no will. Execution will. Okay. Now I'm going to talk to you about different kinds of will. Now, I was talking to you about last will, right? The will I was talking to you about is called the last will and testament. On top, you will see, okay, the last will and testament. That's how it starts off. It is a standalone will. As opposed to that standalone will, we have another kind of will, which is called a pour-over will. What is the pour-over will? It's affiliated with a trust plan. I told. Okay. So now I'm going to talk to you about the trust. What is a trust? So before I talk to you about the trust, and then it's a codicil. What is a codicil? It's a modifying the will. Supposing you have said, okay, it's unequal shares to all my children, and then later on you decide to change it because you are living with one child and she takes care of you and she's in need of financial affairs, so she thinks maybe I should change it. So it's codicil, modifying or addition, it's a supplement to a will. But even a codicil had to have all 5 requirements, and it has to be signed in front of 2 witnesses. There has to be a notarization, whole thing. So in my opinion, I have never done a codicil. What I do is I do the will all over again. Nowadays, it's Word, it's Word perfect, it's online, you just sign up, and then instead of doing a codicil, it's called the will all over again. So once you do the second will, if you do the second will, the first will is revoked. There is a clause saying that I revoke all the wills I've done prior to this. So you revoke all the will which you've done before, then you do this second will, the current will. So that is the effective. The second will or the newest will is effective one. Okay, so that's a little bit about the various kinds of wills. Now we are going to talk. So just to give a recap, if it's no will, it's called the intestate distribution. And also, I just wanted to touch base a little bit about other strategies to avoid probate. There are some real estate, if you want to transfer the real estate without going to courts, you can do now. New York introduced a thing called transfer on death deed, TODD. So you can do a deed, transfer on death deed, TODD. And also that's for the real estate. Transfer on death type designations. You can go to the bank and say, after my death, you don't want to give money now. If you don't want to give the money now, but after my passing, you can put all this transfer on a POD, pay on death designations. You can go to the bank and fill out all the paperwork. So whatever the money you have in the bank after you pass away, so your family members don't have to go to courts and go through these probate or administration proceedings. So if you go to the bank, fill out those forms, then you are squared away. And the survivorship rights associated with joint ownership. If you have spouses, then both own the property, right? So then if one passes away, the whole thing is owned by the surviving spouse. So that's the other way of avoiding probate and getting joint ownership. Those are the ways that you can avoid probate. If you do not have will, it's an intestate succession. So that's out of the way. So now I'm going to talk to you about what time is it? Let me check time. It's 11:52. Okay, so trust-based estate plans. So you would have heard about trust. Okay, so in order to avoid probate, meaning going to courts. Even a will, it has to be submitted to courts. It's going to take about 6 to 1 year. And on top of that, there is a thing called probate fees. Based on your assets, you have to pay a probate fees. About 300, 500,000. I think my friend, lady, she filed the paperwork because her father passed away recently. She filed about $600. So depending on the amount of the assets, you need to pay probate fees. So if you don't want to go to courts, what is the next alternative is to have beneficiary designations, go to the bank and put POD, or you have both your assets, joint ownership on the house. You don't have to go to courts. It's owned by the surviving spouse. And the third alternative is the trust. So what is the trust? Trust is a fiduciary arrangement that allows a third party to manage assets on behalf of someone. So there are 3 persons involved in a trust, and you need 3 certainties. One is the grantor, the next one is the trustee, and the third one is the beneficiary. So the trustee manages the trust according to the rules of the grantor. So the assets in the trust are called the trust form. And trust can be like similar to a person who is driving a car. So the person who drives the car is the trustee. But he has to drive the car according to the grantor who writes the trust and the terms of the trust. He can put anything in the trust. I want this, money to be handled this way, similar to a will, but this is the trust. It doesn't have to be probated. It doesn't have to be submitted to the court. That's his terms, called the terms of the trust. So it has to be the person who is driving the car has to tune his, dance according to the grantor's tunes. And when you are driving a car, you cannot just drive the car. What needs to be done is you have to put all the assets into the car, meaning it has to be funded. That is called funding, meaning once you sign the agreement, like a will, it's an agreement, okay? Once you sign it, that's done, then all the assets have to be retitled into the trust. So when I told you there are 3 people involved in the trust, it's a grantor and a trustee and the beneficiary. There are different kinds of trusts. One is revocable, living trust. It's living trust, meaning you sign the trust when you are alive. Then the other one, as opposed to that, it's testamentary trust. What is a testamentary trust? It's testament, meaning it's in the will. If you have young beneficiaries, you don't want them to handle assets when you pass away and they are young, what you do is you do testamentary trust. You create a trust in the will. So that is a testamentary trust. It becomes effective after you pass away and it's submitted to the courts and then its probate is granted. That is a testamentary trust, as opposed to living trust, which it's handled or you do the trust while you are alive. And then there is another kind of trust, it's called revocable and irrevocable. Revocable meaning you can revoke, you can change, amend it as long as you want, and so long as you have your mental faculty. So usually people, you would have heard about RLT, Revocable Living Trust, to avoid probate, going to courts. Everybody has a revocable living trust. In the case of a revocable living trust, the grantor, the person who signs, do the will, trust, the trustee, and the beneficiary who benefits, the trustee is the one who manages. Everything can be one and the same. Like me, I do the trust. I'm the grantor, I'm the trustee, I'm the beneficiary, I have the mental capacity, and I can handle it. What happens is when you are incapacitated or when you pass away, then the successor trustee comes in. So she takes over and she drives the car. Okay? And so that's how it works. And I told you, funding is very, very, very important. People sign the trust, okay, and then go about it. Please do not go about it. Okay, I signed the trust like a will. Will comes into effect only after death. But trust comes into effect, as I told you, when you're alive. What happens is you need to fund it. As soon as you do the trust, you need to transfer all the assets. If it's the will, if it's you have a property, you need to transfer it. If you have a deed, it has to be transferred into the trust. Now, usually, if you have a real property, free and clear, it will be Evelyn Sylvester, right? That's how we own it. Now it's going to be Evelyn Sylvester, trustee of the Evelyn Sylvester Revocable Living Trust. That's how we are going to own it. A little bit different, but still you own it, right? And bank accounts has to be transferred into the trust. And, deeds and deeds for real estate, right? So that's the difference. Trust, type of trust, living and testamentary. Testamentary trust brings, when a will, and living is effective upon signing. Funding, revocable is easily amended, no asset protection, but irrevocable is not easily amended, but it has asset protection. I work for the Medicaid, and if you want to apply for Medicaid, you need to, so now I don't really have time. Jacob, I don't know. I'm going to go ahead with a little bit of Medicaid planning, but it's time. I think it's 12 o'clock.
Good time, no worries.
No worries. Okay, thanks, Jacob. Okay, so because Medicaid, it's not complete because everybody is interested in Medicaid, because it does cover the long-term care. I know many of you are over the age of 65 in Medicare. However, when it comes to Medicaid, it doesn't cover long-term. So I just want to give you a little bit of heads up, about Medicaid. So what is Medicaid? Medicaid is government-funded health insurance program. And it covers low-income people and families administered through social services district here in New York City is New York City Department of Social Services, which I was working last week, or out of New York City is going to be all, Department of Social, it's all DSS, the Department of Social Services. But here in the New York City, we handle it in New York City. And out of New York City, it's handled by New York State. So if you want to get a claim, you have to write to New York State Department of Health. But here it's New York City Department of Social Services in the city. All right, so that's the difference. All right, so Medicaid eligibility criteria. The myth is people think that if you are poor, you get Medicaid. It's not true. Eligibility for certain categories only. You need to be an SSI recipient, and then you can be over the age of 65, blind or disabled, or disability recipient, or medically needy claimants, meaning if you are on dialysis, end-stage renal failure, Medicaid covers. So those are the types of, so it's only certain categories. Merely because you are poor, you are not going to be covered. If you are under the age of 65 or doesn't have all these requirements, if you are not an SSI recipient, not going to cover. All right, so that's Medicaid eligibility criteria, and Medicaid is means tested, meaning that in order to get Medicaid, there are two kinds you can differentiate between: assets in your bank, which is resources, and income, meaning whatever money you have in the bank is resources. You get income, it's monthly income, you get SSI or pension or annuity dividends. Those are income. So when it comes to Medicaid, in 2026, around, you need the money you can have in the bank is only around 30,000. If you have even $1 above that, you cannot get Medicaid. When it comes to income, similar to that, it's about, don't quote me, it's about 1,500. So if your income, you add up your, to go to Medicaid, an application and say, okay, I don't have health insurance, I need Medicaid. So they have, all your assets in the bank and they have the income. So two things are differentiated, and they will put add all your income and everything has to be transferred. Okay. So if you have excess resources, what's going to happen? You need to transfer into transfer. So how can you do the transfer, right? Okay, before I speak about excess resources, I'm going to cover what Medicaid covers. So there are three kinds of services. One is community Medicaid services, when you stay at home and still get Medicaid for doctors and hospital visits. That's the general. So there is another one called institutionalized nursing. So when you go to nursing home, it's skilled nursing facility. You cannot do certain stuff and then you go to nursing home. So nobody, everybody, if they can handle their affairs at home, they get home health aides. So that is home health aid, is long-term home care. So when you stay at home and still covered by home attendant, so it's called the MLTC. In 2012, it came under the Medicaid long-term. It's called the Medicaid long-term care. So those are the three ways you get Medicaid. So again, between institutional nursing home and long-term care, I told you, when you have even $1 over the threshold of income and assets, you cannot get Medicaid. So what you need to do is you need to dispose of excess resource. So how do you dispose? You have to spend out, meaning you spend it in certain, say you want to buy a TV or certain this thing and bring your receipt and give it back to Medicaid, and then it's gone down. You show the bank accounts, bank statements, gone down below the threshold, then go. Otherwise, you can spend on medical expenses. That's another one. And then you can also transfer it to your loved ones, like your spouses or disabled children. That's the third one, transferring your assets. So when you transfer the assets, timing is very critical. Meaning, to transfer and go to the nursing home. So I told you, between the nursing home and home care, if you go to the nursing home, if you are applying for nursing home, the Medicaid will look 5-year look back period. It will look back for 5 years. And if you have transferred any assets within the last 5 years, then it's called the Medicaid penalty, meaning that you don't have to pay any money. It's not a penalty as the sense that you have to pay money. What will Medicaid do is, if you have transferred any excess assets and if you are planning to go to the nursing home, they will not cover the nursing home expenses for certain months. Depending, so they have a formula and they will calculate. For 3 months, they're not going to cover. So it's a debt on you and you have to pay for the nursing home. That's it. To have excess assets, what you do is Medicaid Asset Protection Trust, called MAPT in short, MAPT. And that's for assets. Then you have the pool trust. Pool trust is for income. I told you, we need to have assets down, also income down. So because income is going to come monthly. So what you need to do is, if you are Medicaid, eligibility, if you want to get Medicaid eligibility, you need to join a pool trust. What is a pool trust? Pool trust is handled by several nonprofit organizations, and they try to help all the adults so that they can be Medicaid eligible for Medicaid. So what you do is more than 1,500, you transfer all the assets into the pool trust. What's a pool trust? You don't sign the pool trust, you join. It's join the agreement. You sign a join that you will see that the join the agreement that you sign pool trust in order for your income to come down below the threshold. So that's disposing of your assets. So transfer penalty for nursing home only. So 5-year look back, transfers within 5 years for less than fair market value. The penalty period for eligibility, meaning 3 months, you are not eligible for Medicaid. You have to pay out of your pocket. All right, why Medicaid planning matters? Because nursing home costs about $12,000. Home care also is cost. You have no planning, your assets will be depleted. And Medicaid, last but not least, I'm going to talk to you about Medicaid. Medicaid is not completely free. I told you, Medicare, if you're over the age of 65, you get Medicare and certain medical services are covered. That's free, except for the services you get from Medicare on your personal injury lawsuits. Like if you meet with an accident and you're over the age of 65, you go to the hospital, the first thing they look is, okay, your Medicare, so they'll cover the Medicare, even if you meet with an accident. And then what happens is you file an action against the personal injury, you get some money out of the personal injury. So you have to pay Medicare and Medicaid. So recovery, Medicare is also recovering when it comes to personal injury, not the regular ones. If you don't meet with an accident and get personal injury law suits and settlements, you don't repay Medicare. But Medicaid is called the pay of last resort. Every Medicaid you get, you need to pay back. So Medicaid is not completely free, and so personal injury awards, before you get your money, you need to call Medicaid. That's what I was doing, Medicaid or recovery. You payment after that. When you pass away, they go 10 years from date of death. So whatever Medicaid you get, you need to pay back, or you need to negotiate and pay a portion of your assets. So that's Medicaid recovery. All right, summary is long-term care is expensive, early Medicaid planning. So you need to protect. In order to protect, you have to transfer all your assets into a trust called Medicaid Asset Protection Trust. As I told you, it's an irrevocable trust as opposed to a revocable one. Revocable one, you can change it, amend it, but in this irrevocable trust, you cannot change or amend it. So with the right plan, you can protect your assets, preserve your home. And when it comes to home, there is another myth, right? There is another myth that you can save your home. When you are alive, your house, your home or apartment is exempt assets. So they don't go after you. You can have it, you own it. But when you pass away, that is also included. And they will factor that into it. And the executor has to settle and negotiate with Medicaid. All right, so that's the end of the presentation. I believe that you got some valuable information from my presentation. And if you do have any questions, you can ask anything.
Yeah, and is it time for any questions, Evelyn?
Sure. I can, I can.
So any folks, if you want to, feel free to unmute yourself if there's any questions that you may have for Evelyn, or feel free to type it in the chat, and I'm more than happy to read that out. Feel free, folks. If you have any questions, feel free to unmute.
I feel my questions might have to do with only me, so.
Oh, and if there's any folks in person as well, feel free to ask any questions as well. But it looks like no one's unmuting themselves on Zoom land. well, if anyone doesn't have any questions, just a little reminder that we have this session recorded, and so we're going to be sending out this video once it's ready for all of those that have registered for the event. So I'm going to send out that email, if anything, along with Evelyn's contact information in case you would like to get in touch just to discuss any estate planning. But with that in mind, oh, Karen, I saw that you unmuted yourself. Do you have a question?
Did, but I actually forgot the question. It was about estate planning. I mean, if you have a property, she's saying the estate planning, when you have property, right? It passes down to the first daughter, even if you have two daughters, something like that. I didn't understand everything she said, but
It passes, you don't have a bill though, right? You don't have a bill? You
no
have
bill. If
no
you
bill.
don't have bills, okay.
So if you don't have a will, it goes downwards, to your husband and children, if you have a husband. Do you have a husband?
No husband, just children.
Children in equal shares. No will, equal shares. No, it goes in equal shares. If you pass away.
Okay.
Net. Okay.
Okay, well, if anything, folks, we can end things here. I see that the time right now is about 12:15. So thank you once again, Evelyn, for such a great presentation. It was very, very informative. And once again, folks, we have this session recorded. So once it's available, I'm going to be sending it out to everyone that has registered for this event, along with others that have requested it on their end. So stay tuned for that, if anything. All right. And then other than that, folks, thank you once again for participating.
Can you hear me?
Really appreciate it. Oh, go ahead. Sorry.
Can you hear me?
Oh,
yeah.
yes.
I didn't mute myself. I guess you did when you did the recording.
Yes.
I have one question about, I have a power of attorney form in front of me. Evelyn, I don't own my apartment. I'm still a renter. What is there's real estate on the power of attorney where I would grant authority to my agents on all those subject matters.
Yes.
What is, so if I don't own my apartment, then I assume I would not, and I don't own any real estate, I don't have to check that off, right? And what is chattel and goods transactions? What does that mean?
I mean, chattel and goods, it's like last will handling all your affairs. Chattel and goods.
I'm sorry?
It's like, it's like anything and everything. It's just a usual jargon, legal jargon. I don't know exactly. Off the bat, I can't even remember. So are you afraid of giving all the powers to anyone? Is that, I believe that's what, based on what you said, that, okay, I don't have the real estate, but, if she has to, if your children, I don't know, depending on circumstances.
No, it'd be my brother and or my niece. My brother's, even though he's older, or my niece I don't have children. So it's going to be my brother and my niece as my agents.
Okay, sure. So my thing is, if you can't trust them to give it all the powers, that's what I would do. But like you're very specific about real estate. Okay, I don't want to put that.
Yeah.
Chattels, and if you still think, you need the initial whatever you don't want, but when it comes to real estate, if they have to pay the rent.
Right. Okay. So it does refer to, if they have to pay rent. Okay.
Rent, in case.
Okay.
Yeah. Of that nature. So in my opinion, if you trust your brother and daughter, the best bet is for you to give A to O, the way I mentioned here. On the down, you see that, right?
Yeah. Also, my other question is, I have some money with the financial planning company, organization, but I should also have my checking and savings account, which is with one bank. I was told I should have a beneficiary form done with them as well. Is that correct?
Yes. all and everything, anything and everything where you can have beneficiary designation. Please, 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 the only thing if you want to do is go to the bank or even your 401k, financial, all the IRAs and all the retirement assets, anything, especially retirement assets, anything and everything except for the real estate, you don't, even for real estate, PODD. So everything and anything and everything, please go. One thing you want to do out of this presentation is go to the bank immediately and get not only one beneficiaries, because he or she may pre-deceased. So get 2 or 3 alternate.
Right.
Not that, because sometimes the person is deceased and you don't change.
Right.
So then you pass away, then there is no beneficiary.
Right.
Yeah.
Okay. Thank
2 or
you.
3, 4, do all anything and everything. Go to the bank, go to the financial institution, 401k, anything and everything. Please, please, please. Go try and do the beneficiary designation.
Okay. Thank you.
Yep.
Okay. I must go. Okay.
Great. Okay, folks. Well, the time is 12:18, so we do have to end things here. But thank you all once again so much for being a part of this wonderful presentation. And thank you once again, Evelyn. We really appreciate you. All right, everyone. Have a great rest of your day, and we hope to talk to you soon. Okay. Bye.